This is Barry Zalma speaking for Zalma on Insurance at YouTube. I am an attorney who has retired from the practice of law and spend most of my time now as an insurance consultant and expert witness and an author. I post a blog daily and write a twice-monthly insurance fraud newsletter called Zalma Insurance Fraud Letter. Today, let's talk about a recent decision on the tort of bad faith, where the court dealt with the lack of existence of coverage and a claim, and therefore, since there was no coverage and no claim, there could be no bad faith. When a woman was on a tour of the United States, she left her tour bus, checked into her hotel, walked into a shopping center of the town and was injured when struck by an automobile, but then attempted to collect underinsured motorist benefits from the tour bus insurance company in a case called Sandrine Mounier versus RLI Corporation, a decision of the United States District Court for the District of Arizona. Defendant, Four Star Season Travel LLC, a California company, is in the business of hiring out buses and drivers to clients for a variety of services, including tours. Sandrine and Gustave Mounier, the plaintiffs, French residents, purchased a tour of the western United States through Geo Tours USA. Geo Tours hired Defendant Four Season to provide the tour bus and bus driver for the tour. On November 10, 2015, the tour bus arrived in Page, Arizona, and dropped the passengers, including the plaintiffs, off at their hotel. After the passengers deboarded, the bus driver parked and locked the tour bus in the hotel parking lot. Plaintiffs proceeded to check into their hotel and explore the shopping district in town. On their way back to the hotel to get ready for dinner, plaintiffs crossed a crosswalk, and while in the crosswalk, Ms. Mounier was hit by a non-party Albert Henry's car and fell on her wrist. The accident was 0.3 miles away from the hotel and occurred about 2 hours after plaintiffs had deboarded the tour bus. Ms. Mounier was taken to a nearby hospital and then transported to Utah for further treatment. Plaintiffs were unable to finish the tour, and upon her return to France, Ms. Mounier underwent surgery to treat her injuries. Plaintiffs recovered the limits of Mr. Henry's insurance policy, and then notified Geo Tours and Defendant Four Season of their claims. Defendant Four Season turned the claim over to Defendant RLI, who had issued a business auto policy including a California underinsured motorist coverage endorsement, to Defendant Four Season. The policy provided that Defendant RLI, quote, will pay all sums the insured is legally entitled to recover as compensatory damages from the owner or driver of an uninsured vehicle. The policy defines insured as, quote, anyone occupying a covered auto, close quote. Defendant RLI denied the plaintiff's claim because it found that plaintiffs did not qualify as an insured under the policy, since she was not occupying the vehicle. Plaintiffs sued RLI alleging breach of contract and insurance bad faith. The policy that RLI issued defines occupying as in, upon, getting on, out, or off. It is undisputed, and was undisputed by the plaintiffs, that at the time of the accident they were 0.3 miles away from the tour bus and were not getting in, on, out, or off the bus. Thus, the plaintiff's coverage determination seems to hinge on whether the plaintiffs were upon the tour bus because of multiple court decisions that have stretched the language of insurance policies to include people close to a vehicle. Under California law, for example, to be upon a vehicle, an individual must be performing some act necessarily related to the vehicle and be in its immediate proximity at the time of the accident. Under Arizona law, an individual is upon a vehicle when the individual's activities at the time of the accident are in such close proximity to the car and so related to its operation and use that they are an integral part of one's occupancy and use of the vehicle. The court found no conflict, since both states require the insureds to be near the insured vehicle and to be engaged in some activity closely related to the use of the vehicle. A choice of law analysis for the breach of contract claim was found by the court to be unnecessary. Moreover, because the facts of the accident were undisputed, the court only needed to decide whether the plaintiffs qualify as insureds as a matter of law. Now, many courts across the country have addressed the issue of occupancy. Plaintiffs were neither walking to or from the tour bus, but had deboarded the bus nearly 2 hours prior to the accident and booked into their hotel, and at the time were heading back to their hotel, not to the tour bus. Plaintiffs argued that both Arizona and California looked to the person's purpose and intent at the time of the accident to determine occupancy. Because plaintiff's purpose and intent was to tour the Southwest, and they were using the tour bus for that purpose, the plaintiffs argued either state would find them to be insureds under the policy. The tour bus was not being used for any purpose other than transporting, and more importantly, the tour bus was not being used by plaintiffs at the time of the accident. Because the court found that plaintiffs were not occupying the tour bus under either Arizona or California law, it concluded that plaintiffs were not insured under the policy, and as a result, their breach of contract claim failed. Liability for bad faith, which was also alleged by the plaintiff, has been strictly tied to the implied-in-law covenant of good faith and fair dealing arising out of an underlying insurance contractual relationship. Where no such relationship exists, no recovery for bad faith may be had. Defendant RLI's motion for summary judgment was granted because there was no coverage under RLI's policy. There could be no possibility of a tort of bad faith. In my opinion, the court opinions that stretch the meaning of in, on, or upon language of an insurance policy caused this case to be brought to a trial court, even though the plaintiff was neither in, on, upon, or even close to the vehicle, but was 3/10 of a mile away walking towards a hotel, not towards the vehicle. It is time for courts to use the simple, clear, and unambiguous language of the policy and conclude that in means the plaintiff must be inside the vehicle, on means the plaintiff must be touching the vehicle, and upon means sitting on the vehicle. It does not logically mean near, close, or within blocks of the vehicle. This is Barry Zalma. You can find my writing and my blog posts like the one we're discussing today at www.zalma.com/blog, and my books are available through Kindle or Amazon.com with detailed descriptions on my website www.zalma.com.